you. Welcome to the March 9th, 2022 Standard of Care meetings. My name is Sang-Oh, chairperson of the committee. Before I begin the meeting, I would like to welcome our newest board member, Indira Cameron Banks. We are excited to have you on the board and as a member of this ad hoc committee. Also, just a reminder, we're going to have video on today for the presentations and during the meeting for us members and for presenters as well. As this is the first meeting of this committee, I would like to thank everyone for your interest and participation in assisting the committee and board with its assessment of whether moving forward to a standard of care enforcement model would be feasible and appropriate for the regulation of pharmacy. Members of the committee include myself, Maria Serpa as vice chair, Nicole Thibault, and Indira Cameron Banks. Again, hello Indira, welcome to the board. We're excited to have you. I'd like to remind everyone present that the board is a consumer protection agency charged with administering and enforcing pharmacy law where protection of the public is inconsistent with other interests sought to be promoted. The protection of the public shall be paramount. This meeting and all other meetings convened to discuss this topic will be held in public forums, providing an opportunity for all interested stakeholders to provide comment and information to members, ensuring transparency. The information learned today and at future meetings will be shared with the full board at appropriate times as agendized. This meeting is being conducted consistent with the provisions of Governor Gavin Newsom's Executive Order N-1-22, which extended provisions of Government Code Section 11133. Participants watching the webcast will only be able to observe the meeting. Anyone interested in participating in the meeting must join the WebEx meeting. Information and instructions are posted on our website. Today's meeting will consist of several presentations and will provide committee members and stakeholders present an opportunity to receive information and begin initial discussions. We respectfully request that everyone participating today do so in a respectful manner. Following the various presentations, I will open up for questions by members to each of the presenters. Following all of the presentations under agenda item 5, discussion will be open to all individuals present. To ensure all interested individuals have an opportunity to provide public comments during the meeting, I will announce when we're accepting public comment. Following the presentations under agenda item 5, I have advised the meeting moderator to allot 5 minutes to each individual providing comments. As it is anticipated further dialogue may be necessary, individuals will have the opportunity to provide comments more than once. Individuals wishing to speak again should re-queue in the Q&A feature that will be discussed shortly. This approach is necessary to facilitate this meeting and ensure the committee has the opportunity to complete its necessary business. I appreciate everyone's understanding. Before we get started, I would like to ask the meeting moderator to provide general instructions. Moderator?
Good morning and thank you. For today's public comment period, we will be utilizing WebEx's question and answer feature, which you will hear me refer to as the Q&A. At the time of the meeting in which the chairman calls for public comment, I will announce that I'm opening the Q&A panel and display the following instructions. You'll want to locate that Q&A icon on your screen, which is typically located in the bottom right corner. It looks like a question mark inside of a square. If you click on that icon, it will open a text box, and in that text box, you can type the word comment and submit that to our panelists. For those who are calling into today's meeting and do not have access to that Q&A feature, you can raise your hand by dialing *3. We will be taking comments in the order that they are received today, and as the chairman mentioned, we will be allowing 5 minutes for comments. I will provide a 15-second warning when your time is about to expire, and when your time expires, I will mute your microphone and move on to our next commenter. And with that, I will turn it back over to Chairman O.
Thank you, Shelley. Appreciate it. I would like to take a roll call and establish a quorum. Members, as I call your name, please remember to open your line before speaking. Maria Serpa?
Licensee member present.
Hello, Maria. Thank you. Indira Cameron Banks?
Present.
Hi, Indira. Welcome. Indira is our brand new public member. Nicole Thibault?
Present.
Thank you, Nicole, and I am here. All right, the quorum has established. Also a reminder, our wonderful executive officer, Anne, is also here with us to always help us and guide us through. So thank you, Anne, always. With a quorum being established, the committee will now entertain any public comments for items not on the agenda. To facilitate this portion of the meeting, as I previously announced, the meeting moderator will open up the line for individuals to provide public comment. You're not required to identify yourself, but may do so. As we open the lines, I would like to remind everyone that the board cannot take action on these items except to decide whether to place an item on a future agenda. Members, following review of the public comments for this agenda item, I will survey members to determine if any members have preference for items be placed on a future agenda. You'll have 2 minutes to provide your comments. Moderator, sorry, I just noticed Nicole disappearing into the wilderness over there. Hopefully she's okay. Moderator, please open the line for public comments.
And this is the moderator, and we have opened that Q&A panel. Again, if you'd like to make a comment, use that Q&A icon to access the text box. In that text box, type and submit the word comment to our panelists. If you are a calling user and do not have access to the Q&A panel, you can raise your hand by dialing *3. Our first comment comes from Michael Mattis. Michael, I've sent a request to unmute your microphone. You'll need to click the unmute me button that appears at your end. One moment, I think he's having some technical difficulties.
Hi, good morning.
Good morning.
Yeah, it's I was trying to figure out how to get to the comments section, and I inadvertently pushed the hand up, so I apologize. I'll come
That's
back
okay.
later. Thank you.
And with that, I'm not seeing any requests for comment. Would you like me to close the panel?
Yes, please. Thank you
It
so
is
much,
closed.
Kelly. All righty, so with no comment, we're going to move right on to the agenda. Item 3, presentation on standard of care provided by the Office of the Attorney General and Department of Consumer Affairs. Members, the first presentation today will be a joint presentation with representatives of the Office of the Attorney General and DCA Legal Office. I would like to welcome Deputy Attorney General Christina Jarvis, Deputy Attorney General Nicole Trauma, and DCA Counsel Eileen Smiley. Please begin your presentations when ready. And again, thank you so much for coming and providing this presentation. The floor is yours.
Good morning. Good morning to the committee and to all of our attendees. I am Christina Jarvis, Deputy Attorney General, and I'm going to kick us off. And then since we are not in person, it might get a little bit awkward as we pass the baton from one to the other, but we will do our best. So as you said, this is a presentation on the standard of care. We are going to discuss the standard of care model that we would anticipate if such a standard of care model were to be adopted by this board, by the legislature. And then we're going to discuss also some drawbacks to both a standard of care model and the current regulatory model. So looking at my screen, it looks like whoever's speaking is generally sort of pushed to the top. So I'd like to have my co-presenters go ahead and introduce themselves as well.
Good morning. I'm Nicole Trauma. I'm a Deputy Attorney General with the Office of Attorney General.
And good morning. My name is Eileen Smiley. I'm the DCA counsel assigned to the board and serve as board counsel for the Board of Pharmacy.
Great. Thank you, guys. All right, so I'm going to move on to the next slide. And this is obviously our Attorney General seal, and it discussed that we represent state agencies and employees in judicial and other proceedings. And now Nicole and I do represent multiple agencies. We represent all of the agencies, or almost all of the agencies contained under the DCA umbrella, which I believe at last count was approximately 36, but don't quote me there. Our focus is on the prosecutorial side of things. We really focus on the discipline of licenses, on when applications for licensure are denied. We do the statement of issues. So our focus is very prosecutorial in nature. Where by contrast, if we can go to the next slide, Eileen can talk a little bit about DCA's focus.
Yes, and the Department of Consumer Affairs, as Christina mentioned, is an umbrella organization. It has most of the boards and bureaus under California law that require licensure. We currently administer over 3 million licenses for more than 280 license types, from architects to accountants, doctors, and for this board, for all pharmacy personnel and also pharmaceutical facilities. DCA protects and serves consumers in the following ways, similar to the board, that we are a licensing entity, we are also a regulator, and we're also an educator. The Board of Pharmacy, unlike DCA, also has an enforcement mandate as well. And then if we could go to the next slide. Standard of care, we're talking about why is this important? And in the board's last sunset review, the legislature asked the board to convene a working group by July 2023, detailing whether moving to a standard of care enforcement model for pharmacy law is both feasible and appropriate. They did this by adding a section to the Business and Profession Codes that expires or is repealed effective January 1st, 2024. So the board's work on this report that will be transmitted to the legislature must be completed by January 1st, 2024. So in coming up with this presentation, we thought it would be helpful to understand what a standard of care model is and how it's used before the board and particularly this committee begins its discussions that will form the basis for drafting this required report. This presentation is for informational purposes only and does not provide a position about whether the board or the legislature can and or should move to a standard of care enforcement model. The board's required report is essentially to assist the legislature in deciding whether to revise pharmacy law in California to move to a standard of care model. Any action that will be needed to implement this must begin at the legislature. The board doesn't have any power to obviously amend the statutory provisions of pharmacy law. Christina or Nicole, do you have anything to add? No.
I don't think so. No.
Next slide,
you
please.
covered it. Thank you, Eileen.
Okay, and the current structure of pharmacy law covers a lot of areas. This is obviously general. We deal with the licensing requirements for pharmaceutical personnel and facilities. It also includes authorized scope of practice for pharmacists, what they can do independently, what they need to do if they can't actually prescribe or initiate treatment. It also has authorized scope for other pharmacy personnel, including pharmacy technicians that assist pharmacists and intern pharmacists, which are largely pharmacy students. It also has a lot of prescriptive rules that I would say establish minimum operational standards for licensed facilities, say such as pharmacies or wholesalers and other types of entities that are licensed by DCA. Some of the statutes and rules are detailed and some are governed by a standard of care already. For instance, a DUR is what's called a drug utilization review. And basically, when a pharmacist is given a prescription for a patient, they're supposed to review what the drug's interactions are with other drugs taken by the patient. So although the law requires that they do what's called a DUR, it doesn't detail in great detail how they go about doing that. I would say it's governed by a standard of care. Christina or Nicole, do you have anything?
Nope.
All right, next slide, please. In addition to the state laws governing this industry, there are also different federal overlays that establish certain requirements. They don't deal with, like, say, operating procedures of a pharmacy or anything like that, but you have different requirements. So, for instance, the distribution, storage of controlled substances is also subject to the Drug Enforcement Agency rules with respect to how they have to handle that and secure access. And controlled substances, as everybody knows, are some of the more addictive drugs, depending on what the schedule is, Schedule 1 through 5. Also, the Federal Food, Drug, and Cosmetic Act also has different rules that impact the practice of pharmacy in many areas. The Food and Drug Administration is the federal agency that administers this act, and among other things, they have different requirements. Like, for instance, if there's an approved FDA drug, then pharmacists are supposed to use that unless there are other exceptions that apply or when you can use generics. So in addition to the state laws governing pharmacy practice, there's an overlay of federal law as well in different areas. Christina, Nicole, you have anything?
I'd like to add here, and this is a spoiler alert, but, you know, obviously anything that California does to change their laws, if they were to decide to adopt the standard of care model, would not affect in any way these federal laws. So that's an important thing to keep in mind as we discuss these different standards of care models. We're discussing California law here. We're not discussing changing any of these federal laws that do affect and implicate pharmacy law to a large extent, particularly when you're talking about, you know, compounding, sterile compounding, and many other areas of pharmacy law.
We can move to the next slide. This brings us to the current disciplinary process. Under Business and Professions Code Section 4301, the board can take disciplinary action against a licensee for unprofessional conduct. And unprofessional conduct includes, among other conduct, violations of the statutes of California or the United States regulating controlled substances or dangerous drugs. Unprofessional conduct includes violations of for incompetence or gross negligence. This would be a violation of the standard of care. An example of this could be where a pharmacist misses an FDA warning of a risk when conducting a drug utilization review. And while the Board of Pharmacy does not have a regulation that specifically defines incompetence or gross negligence, typically gross negligence has been defined as an extreme departure from the ordinary standard of conduct, and incompetence as a lack of qualification, ability, knowledge, or fitness to discharge a professional duty or obligation.
And if we can move to the next slide. In general, we would call this current California disciplinary process a hybrid model. It's a hybrid disciplinary model involving the potential for discipline for violating state or federal statutes or rules regulating controlled substances or dangerous drugs, but it also includes violations of the standard of care. Now, discipline can be imposed against a licensee for their own conduct in violating statutes, rules, or standard of care. And again, similarly, when the pharmacist does not provide a consultation when required or misses a contraindication identified in FDA warnings on such a drug. But discipline can also be imposed against a pharmacist for violations of law by pharmacy personnel under their supervision, such as pharmacy technicians or intern pharmacists. But also, don't forget, pharmacists in charge are responsible for a pharmacy's compliance with all state and federal laws pertaining to the practice of pharmacy. So pharmacists in charge, PICs, also can be disciplined for a pharmacy's violation of such laws, even if the PIC is unaware of the practice. And we consider this to be a strict liability standard. So if a pharmacy is in violation of any law, regulation, or rule governing pharmacy, it is the PIC's responsibility to know about that violation and to fix that violation or prevent it from happening in the first place. And because that is their legally mandated responsibility, they are liable for all actions taken by the pharmacy. And again, we are focusing here on discipline rather than the specific practice of pharmacy. But all discipline does relate back to the specific practice, of course, because it is a deviation from that practice. And what we really wanted to emphasize here when we're talking about the current process is that there is already a standard of care model or system partially in place here. Because even though the practitioner can be disciplined for violating specific statutes or regulations, they can be disciplined for acting with such gross negligence or such incompetence that they fail to meet the standard of care in their practice. And we're going to talk about some of the definitions coming up in just a moment, but I can tell you from my own, again, prosecutorial focused experience that I have charged pharmacists in particular with incompetence and gross negligence and been successful. When the practice of pharmacy drops so far below the standard of care that it can harm patients, even if there isn't, or generally there is a specific statute that is on point, but the practice is so far below what any pharmacist would consider to be acceptable practice, that's when these incompetence and gross negligence terms start coming into play. We can go to the next slide.
Yeah. So we also wanted to talk briefly about where standard of care came from. And basically, it arose in law historically in the context of lawsuits in which one person is harmed and suing another person or entity for their harm, saying that they breached a standard of care. The standard of care in those instances is that of an ordinary or reasonable person, and the amount of care usually is in proportion to the danger to be avoided based on reasonably foreseeable consequences. The standard is objective. The ordinary reasonable person doesn't necessarily exist. It's what a court or a judge will determine an ordinary or reasonable person based on what they foresaw, in the realm of potential consequences to be avoided should have done. Generally, what is due care under the circumstances is a question of fact for the jury. However, the standard of care can be established in judicial decisions that will set out what the standard of care should be, or in statutes or regs. So, for instance, lots of times there will be testimony about custom, what is customarily done by pharmacists or an entity in a certain area. And custom is always relevant, but it's not determinative. Basically, what old court cases would say, what is commonly done isn't necessarily what should be done based on reasonably foreseeable consequences. So, for instance, if someone violates a rule or statute that is on point, the violation of the rule or statute is deemed to be a violation of the standard of care, and this doctrine under legal jargon is referred to as negligence per se, for instance. And this doctrine of negligence per se, i.e. you can be held liable for a breach of standard of care by breaching a pertinent statute or reg, has been applied in a professional context in medical malpractice cases. And under California law, this idea of negligence per se, i.e. if you violate an applicable statute or rule, has been codified in the evidence code as a presumption affecting burden of proof. And in different cases, generally it's the person who is suing has to prove that the person they're claiming caused their harm breached a particular duty. Well, if you shift the burden of proof, then basically the plaintiff only has to prove a violation of the applicable rule or statute, and then the burden shifts to the other person to show or to prove that they actually complied with the applicable standard of care. Christina, Nicole, do you have anything to add? You'll be covering some of this in greater detail. It's why I don't want to go into some of the specifics in the disciplinary context.
Absolutely. Yeah, no, go ahead and move on to the next slide.
And as Christina and Nicole have mentioned, California law is currently a hybrid structure that incorporates for the enforcement model, both state and federal laws. So if you violate an applicable state or federal law governing pharmacy practice, then you could be subject to discipline. And it also has standard of care provisions built in. What we just wanted to talk about is, as we all know, when statutes are developed by the legislature, they're generally considering not just, practice, but other competing interests. And they can be motivated by patient safety or other societal interests. For instance, in a lot of the requirements for controlled substances under California law, including the move more to e-prescriptions and different requirements with respect to that, they're tied to reducing diversion of addictive drugs, and potentially those being, if there's a diversion of addictive drugs out into the community, it can increase different addictive behaviors and make it easier for people to get those drugs. The standard of care is a treatment that another reasonably prudent practitioner would give to a patient. From a practical standpoint, generally, if it comes down to a standard of care argument that a pharmacist or a pharmacy intern or a pharmacy technician breached an applicable standard of care, this is going to be proven at trial by kind of dueling expert testimony hired by both the board and then also the licensees that may be subject to potential discipline. Generally, the legislature and the board are not usually engaged in the actual development of clinical standards of care. And so one of the areas that you may want to look at is you can look to professional organizations, learn treatises, and if we move to this type of model, maybe potentially defining where those sources would come from. Christina, Nicole, do you have anything to add?
Not at this point.
No, we can move on to the next slide. We wanted to talk about some of the other agencies under the Department of Consumer Affairs and how they operate. So the Board of Registered Nursing, they operate primarily as a standard of care model. Under Business and Professions Code Section 2761, the Board of Registered Nursing may take disciplinary action for incompetence or gross negligence in carrying out usual certified or licensing nursing functions. Those terms are further defined in the Nursing Board's regulations at Title 16 of the California Code of Regulations. Gross negligence is defined by the Nursing Board to include an extreme departure from the standard of care, which under similar circumstances would have ordinarily been exercised by a competent registered nurse. And such an extreme departure means the repeated failure to provide nursing care as required, or the failure to provide care or to exercise ordinary precaution in a single situation which the nurse knew or should have known could have jeopardized the client's health or life. The code does not require actual patient harm. As for incompetence, the Nursing Board has defined it as the lack of possession of or the failure to exercise that degree of learning, skill, care, and experience ordinarily possessed and exercised by a competent registered nurse as described in section 1443.5. Now, 1443.5 lists the standards of competent performance, and that section states a registered nurse shall be considered to be competent when he or she consistently demonstrates the ability to transfer scientific knowledge from social, biological, and physical sciences in applying the nursing processes. The nursing processes are further outlined in that regulation. The full list can be found in that code for those of you who want more information. But this is how the Board of Registered Nursing typically operates under their standard of care model.
And one thing I wanted to emphasize here, and you can see from this, and if you review section 1443.5, is how broad and general these terms are. This does become, when we get to hearing, a real focus on, what do each of these terms mean? And sometimes you're picking it apart word by word, sentence by sentence, but also act by act. And so you really get into the weeds to some extent in regards to which acts that this respondent took do fall within the standard of care, do fall within competent performance, and then do not, where exactly is that line crossed? So if we can go to the next slide, this is the Medical Board of California. Business and Professions Code section 2234 states that the board shall take action against any licensee who is charged with unprofessional conduct, which includes violating any provision of that chapter, so the Medical Practice Act, and then gross negligence, and then repeated negligent acts. And so that's an interesting focus because it's not just a single negligent act. It has to be repeated acts in order to qualify in this statute. And it's very interesting when you look at what that exactly means, the repeated negligent acts. Because there is case law, there have been cases that basically say that if you're engaging in a course and the entire course of treatment is negligent or based on a negligent sort of predicate, that is one negligent act. So you have to have multiple acts, and that would not include whatever multiple acts are required by starting from this single negligent, assumption or predicate. So that can get interesting and complicated. But then the medical board defines gross negligence as the want of even scant care or an extreme departure from the standard of care. And then negligence is the failure to use that level of skill, knowledge, and care in diagnosis and treatment that other reasonably careful physicians would use in the same or similar circumstances. This is sometimes called a, quote, simple departure from the standard of care. The dental board also has a similar repeated negligent acts provision. And it's always interesting during hearing to hear how the experts, other practitioners, and then the administrative law judge or the ALJ quantify the departure from the standard of care. The phrase simple departure, I just referred to that. In general, I don't find that practitioners do refer to a simple departure because it's never simple. This is medicine that we're talking about. This is not, there are very few things that are very simple in medicine. It's always a course of conduct. There are always context, reasons, circumstances. If, for example, one practitioner might say that operating on the wrong knee is an extreme deviation from the standard of care, while another might say, well, that's only a simple deviation because at least it was the same body part. They didn't come in and operate on an elbow when they were supposed to operate on a knee. So perspective, context, and the information the practitioner has or knows at the time that they make the mistake all become factors that have to be calculated into these deviations. Is it simple? Is it extreme? And then if it's simple, is it repeated? And we can move on to the next.
And very similar to the Board of Registered Nursing, the Board of Vocational Nursing and Psychiatric Technicians also operates primarily as a standard of care model. They have defined gross negligence for vocational nurses as a substantial departure from the standard of care under similar circumstances would have ordinarily been exercised by a competent licensed vocational nurse and which has or could have resulted in harm to the consumer. An exercise of so slight a degree of care as to justify the belief that there was a conscious disregard or indifference for the health, safety, or welfare of the consumer shall be considered a substantial departure from the above standard of care. So this code includes actual harm to a patient, but also includes conduct that could have resulted in harm to a patient or consumer. As for incompetence for vocational nurses, this board has defined incompetence as the lack of possession of and the failure to exercise that degree of learning, skill, care, and experience ordinarily possessed and exercised by responsible licensed vocational nurses. And at a hearing, I've had both vocational nurses and registered nurses serve as experts for the board to testify about the standard of care for vocational nurses. Christina, do you have anything to add to that?
Just in general, when you are seeking an expert to testify in these matters, you want somebody with the same level of licensure. So you would want a vocational nurse to testify about a vocational nurse, a registered nurse to testify about a registered nurse. However, registered nurses do frequently supervise vocational nurses, which is why that sometimes we can, or we do, use registered nurses as experts. And that could have implications for pharmacy as well. You would have a pharmacy technician who would be your expert to testify about a deviation of the standard of care for a pharmacy technician. We also have advanced practice pharmacists. So you would want an advanced practice pharmacist who specializes in the area that we're discussing that would then testify as an expert in a case involving an advanced practice pharmacist. So just to relate it back a little bit to pharmacy specifically. If we can move on to the next slide. Now, here's an example of what is pretty strictly a regulatory model. And the California Board of Accountancy is a very complex profession. It is highly regulated, and it is highly regulated specifically for the protection of the public. Accountancy is subject to both state and federal regulations, as well as the IRS, the SEC, and I can't even tell you how much other industry guidance. Every time I do an accountancy case, I learn 5 or 6 more new industry guidance terms, which are really interesting. They're very interesting cases. I have no idea how the accountants keep them all straight, but somehow they do. Now, accountancy obviously is not a healthcare profession. Patients' lives are not as at risk as in pharmacy or in the other examples that we have discussed. It's unlikely that somebody could have a bad medication response because their accountant did their taxes wrong. However, accountancy is a very essential profession, and it is highly important to our society and to the public. You may or may not know, but accountants are required to have specific language in just their engagement letters, the letters where they set forth the duties that they are going to be performing for this client. They're required to have specific language, specific calculations, specific, even to the point of text size or font size in their documents, but also in their reviews of financial statements, compilations, audits, and much more. People's livelihoods depend on this work, people's financial lives, and people base important financial decisions on the information provided to them by accountants. I referenced the SEC on this slide. People make decisions on investments that can be multi-million or even billion-dollar investments based on information provided by accountants. So even though it's not your actual physical life that can be destroyed, it is certainly your financial life, which can cause significant problems. So when you look at the Board of Accountancy and their regulations, you'll have your statutes, your regulations, your treatises, your SEC, your IRS guidance, and every accountant has to review all of these essentially annually, right? Because things change pretty quickly in the accountancy world. So it is highly regulated. That makes it, to some extent, easier to identify the specific deviations. For example, if it says that in your engagement letter, you have to have a disclaimer in 12-point font that this is your opinion, or other specific language, and you have it in 10-point font, that's pretty easy to prove. If it's in 14-point font, that might be different than what the regulation says, but it meets the intent of the regulation, which is that something is easy to identify and that we know that the client, not the patient in this case, but we know that the client actually has reviewed that information because it is set forth in this engagement letter. And then both the accountant and the client are required to sign that they have reviewed this letter. So what's nice about the regulatory model here is that you do have so much background information that when you're looking at any review, any compilation or audit, you can easily compare. I say easily, it takes forever, but you can compare it to the treatises and say, does this meet section 100.200.3. And, you can easily make that comparison, put it up on a PowerPoint and be able to show whether or not it actually meets that section. Anything to add from Eileen or Nicole?
I don't think so. We can move on to the next slide. So we wanted to switch gears a little bit and explain just kind of the benefits and the drawbacks of both types of enforcement models. So starting with the benefits of a standard of care model, there are a lot of benefits. The standard of care can shift over time as practices evolve. And therefore, this type of model may be more flexible to apply to unique factual situations. And given the nature of the standard of care model, the legislator and the board would not need to have to update or change laws and regulations as frequently. And of course, there are simply fewer laws and regulations for licensees to have to learn and follow as opposed to a regulatory model.
And if we can go to the next slide. Now, some of the drawbacks of a standard of care model is that laws can be less explicit. And I think we saw that particularly when we're looking at some of these examples, which can cause practitioners to have doubt about what is or is not permissible in the standard of care and how they would be held accountable for standard of care violations. So in several cases that I've had involving standard of care violations, the healthcare practitioners come in and said, look, this is how I was trained. Yes, I went to school. They taught me the right way to do things, right? And then I got my first job and they told me this is how it works in the real world. This is what all of my supervisors and all of my coworkers did. I thought that was the standard of care. And that's always troubling. But it's also something that can be kind of difficult to really grasp because there are so many different healthcare settings that we have to really focus on. Are we addressing a healthcare setting in like an ICU, cardiac care unit, or in a much lower level of care, an outpatient clinic or something like that. So boards do have to rely on expert testimony to establish the standard of care. And then that can mean that cases can turn into a battle of the experts. And to some extent, that can be a battle of finances. Not to put too fine a point on it, but I've had cases where my expert was getting paid less than $100 an hour and the opposing expert was getting paid approximately $1,000 an hour. Like that's may or may not change anybody's opinion, but it's something that when we're asking these questions in the hearing, it's something that the court does take into consideration. Now, the standard of care also can change based on location or practice setting, as I was just referencing. But for example, a busy practice in downtown Los Angeles may differ from a slower practice in a small town in the mountains, like Susanville or Quincy, or from a chain store like your CVS, your Walgreens that's doing so many prescriptions to an independent, mom and pop style pharmacy. Or a busy hospital pharmacy to an independent mom and pop style pharmacy. This could create differing standards in California. And again, going back to that discussion of experts and wanting to have the same level of licensure when you're discussing these cases, it would be very difficult to take somebody from a super busy hospital pharmacy in downtown Los Angeles and ask them what the standard of care is for a mom and pop pharmacy where you have literally one pharmacist in town up in, Susanville or Quincy, up in that area. So these differing standards can be difficult to contemplate, difficult to manage, and can cause confusion both for the board and for practitioners and also for patients. If somebody lives in Los Angeles and is used to one set of standards and then is on vacation up in Quincy or Susanville, and I keep referring to them because they're the county seats and so I'm familiar with them and I know that they're small towns, that can cause some conflict for the patient as well. And then finally, and this goes back to a point that Nicole made, the standard of care model may not take into account the different competing interests weighed by the legislature in enacting these specific requirements. So the standard of care model is not going to take into account the public policy interest of preventing a diversion of controlled substances, right? That's not what the standard of care model is designed for. It cannot really in any way take into account those types of public policy issues that the legislature does believe, or has in the past believed, is important, and has enacted statutes and regulations to help prevent that diversion. And so, you know, in the case of pharmacy, also, I do want to remind the committee that while changing to a standard of care model may expand practice in some settings because of these benefits and drawbacks that we've been discussing, again, it's not going to change those federal statutes or regulations that will still be guiding the practice of pharmacy moving forward. We can move on to the next slide.
And to discuss the benefits to a regulatory model, as we've kind of already hinted at here, statutes and regulations tend to be very explicit, clear, straightforward. It provides clear guidance about what is allowed or prohibited. It's very black and white, and in turn, licensees, enforcement staff, and the public can all appreciate that clarity. This type of model also allows the public to engage in the rulemaking process. They, get to have a voice in what the regulation is going to look like. A regulatory model can also ensure that licensees are following, the same rules, and it can help promote consistency and standards across the state of California. And it is also important to note that courts are deferential to agencies' interpretations of regulations, whereas courts may need a little more guidance in evaluating or weighing sources of expert testimony.
And if we can move to the next slide. There are, of course, as with everything, drawbacks to the regulatory model. Statutes and regulations that become out of date could be a barrier to rapidly evolving pharmacy practice. We're seeing a lot of changes in technology right now. We're seeing a lot of updates. We're seeing, just a lot of different things coming through, and that is something that I think we can expect, we can anticipate to continue. And so statutes and regulations, they take a while to change. They have to go through the rulemaking process. They have to go through the legislature. And so that could potentially be a barrier to what might end up being good changes to, the rapidly evolving pharmacy practice. Statutes and regulations are time consuming, and they can be hard to change in a specific period of time. Again, going through the legislature, going through the rulemaking process, it's not instant, it's not immediate. I don't think a standard of care changes instantly or immediately either, but certainly much, much quicker. Statutes and regulations do require amendments to stay current. So similar to how long it takes to actually enact a statute to begin with, to come up with it from nothing, from a blank piece of paper to an actual statute, to getting a sponsor, to going through the legislature. Amending a statute is essentially the same process. It might be a little quicker because you're not starting from a blank piece of paper, but not that much. It takes a while. And that's one thing that is, I would say, a constant complaint about the regulatory model, is that it does take a while. This is not something that can change overnight, and you may argue that it's not something that should change overnight, but that's a discussion. That's an argument to be had. And then finally, it's just more rules and regulations to remember and follow. And again, we're not talking about changing any of the federal rules or regulations. Those will all still be there. But a regulatory model does have to set forth each step, every process that can be done and can't be done, versus saying, meet the standard of care. And as long as you meet the standard of care, we essentially don't care how you meet it. So that can be complex. That is one of the things that does make pharmacy and accountancy, as I discussed earlier, complex professions, because they do have so many rules, so many regulations, so much industry guidance that really must be followed. And we can move on to the next slide.
And before the committee considers the feasibility or appropriateness of switching to a standard of care enforcement model, we may want to consider how stakeholders wish to use the standard of care model. Do they want to use it to replace minimum operating standards in pharmacies and other facilities? That could have a different conversation, different stakeholders and different concerns. Or to broaden a pharmacist's scope of practice based on self-determined education or skill. As we know, pharmacy law currently has general authorizations for pharmacists to practice, but in California, pharmacists have got, under existing law, the ability to independently administer and start treatment in certain areas, including vaccines, subject to certain conditions. We spent a lot of time with the COVID-19 broadening that out beyond just what I would call standard vaccines to anyone that was approved or authorized by the FDA, including like the COVID vaccines that were first approved or authorized under emergency use authorization rather than something that's on the routine schedule like a flu shot. Pharmacists also have got the ability to initiate certain treatment, PEP and PrEP deal with HIV treatments, but there are detailed protocols with respect to what they can and cannot do. Also, a standard of care model could be used to authorize discipline only in cases where maybe a pharmacist breached a standard of care to a patient, similar to the medical board, where under the rules, doctors can be disciplined for violations of other practice standards in the Medical Act, but the board's been ordered by rule to concentrate and prioritize its investigations and disciplines for cases involving only gross negligence or repeated acts of negligence. And as Christina or Nicole stated earlier, currently under California law, pharmacists can be responsible, their licenses can be disciplined, or they could get fines and citations, not only for their own violations, but for violations of pharmacy interns or pharmacy technicians who are working under their supervision. And also the pharmacist in charge, the PIC, is responsible for ensuring compliance with all laws. So I would just state that it would be a good idea to try and pin down exactly what they want to replace in pharmacy law, whether it's all rules, regs governing the scope, even dispensing drugs, or only when a pharmacist is exercising his or her clinical judgment, like for instance, doing a drug utilization review. I think it can inform the discussion.
Okay, we can move on to the next slide. We wanted to point out at least one example where the standard of care was discussed as it relates to Board of Pharmacy enforcement actions. In the board's precedential decision in the matter of the accusation against Pacifica Pharmacy, the board looked at standard of care for pharmacists, particularly how it relates to pharmacists' corresponding responsibility. That decision is available on the Board of Pharmacy's website. At page 11 and 12, there's a wonderful discussion about the standard of care. And in summary, it found the standard of care requires a pharmacist to use professional judgment when dispensing controlled substances, a duty that entails more than filling a prescription. Then it goes on to explain what a pharmacist must evaluate and consider under the standard of care, including the red flags. The decision also discusses how this particular pharmacist in the Pacifica case deviated from the standard of care. In this precedential decision, the board determined that a pharmacist does not meet the standard of care simply by selecting the proper pharmaceutical product, accurately labeling that product for use, and counseling the patient. The board found that reasonable inquiry is required. And then the decision went on to explain what reasonable inquiries need to be made, and states the standard of care requires a pharmacist to consider these matters before dispensing a controlled substance. So then the board in turn found violations of the standard of care in the Pacifica case, that those violations constituted gross negligence because they were an extreme departure from the ordinary standard of conduct. So this is just, one example of how the Board of Pharmacy has used standard of care in enforcement actions. We can go to the next slide.
So just some final considerations. Obviously, our elected officials have spent considerable time drafting a structure for pharmacy law that balances consumer protection and other competing interests. And the board has spent considerable time and effort developing regs, educating licensees and the public, and enforcing them. The changes necessary to transition to a standard of care model will depend on the final determination of how to use the standard of care model in pharmacy law, which will come from the legislature. Obviously, the board's report to the legislature may be a starting point for them in starting to evaluate whether this move is both appropriate and feasible. And either way, as we keep stating, pharmacy will continue to be an industry that is highly regulated by both the federal government and other things, just given some of the public health safety concerns. So you're still going to have the DEA, you're still going to have FDA requirements, even if California starts to remove some of the really rules-based prescriptions. And by that, I mean just prohibitions and rules and statutes.
All right, so that brings us to the end. If we can go to the next slide. Do we have any questions?
Thank you so much, Christina, Nicole, and Eileen. Great presentation, very much. And so now I'd like to provide members the opportunity. I'm going to go with Maria. Go ahead and ask away.
I think President O, you called on me. You were buffering there for a minute.
Oh, sorry. Yeah. So I would say thank you for the presentation, and then I missed who raised hand first, so I'm just going to go with who's on the screen on my end. So Maria, that's you. So go ahead.
Thank you. And I thank you all for that wonderful presentation about our current status and our background and a little bit about our history. I do appreciate the comparison to other professions, especially the other healthcare professions, but found the accountancy one very interesting. But my question is really about your impressions, and you kind of touched on it, on a different licensee category. We talked a lot about pharmacists, and I kind of got a lot of that out of your presentation. But I wanted to hear what your thoughts are about pharmacy locations or pharmacy operations, where we have a lot of regulations that are very detailed regarding sites and pharmacies. And many of them are in advance of the national standards. And that's to protect the patients in our state. So we have more stringent regulations than are nationally recognized, and perhaps even not very popular by many in our state. So the standard of practice may be even a little bit lower than the pharmacy board's expectations, because our patient safety is paramount. A couple examples, just to give you some examples where I'm thinking about for pharmacy locations, is in compounding. Compounding, sterile compounding, non-sterile compounding, USP, national standards typically say shall, which makes it a judgment choice. Whereas in California, we say must in many places, which makes it not a choice, but a requirement. If this were to go to a standard of care, we may lose that higher level of review. I guess I don't know what the right word is. The other one is our current, which this has been recently updated, is on controlled substance reconciliation. We have dictated very minute details. I know that seems a lot, but pharmacists seem to like details too, about how that is done and what is done, because there have been controversies about what is included and was not included. So if we were to do a survey of the pharmacy practice, they may disagree with where the board is, because the board has, again, a more stringent, higher level of expectation for patient safety and to assure that the adequate reconciliation is done. So lots of background, but maybe one or all of you could speak to pharmacy locations instead of the person.
Yeah, and I can start with that. I mean, I think that you have sort of put your finger on one of the issues with the standard of care model, right? Which is that you are correct. California does lead in many ways the nation in regards to some of these standards. And so it depends on how the standard of care model would be developed, right? And we don't know that yet. We don't know if the board will end up recommending that this is changed or it isn't changed. We don't know what the legislature is going to do or what it would look like if they did. But that's one of the things that I was touching on in one of my slides in regards to the standard of care in different practice settings, going from your busy hospital setting to your compounding pharmacy setting to even your sterile compounding pharmacy or your hazardous compounding pharmacy, to your, again, mom and pop pharmacy shop in the mountains of Northern California. These are different. There's massive differences between how the practice goes in these specific, I would say, different industries in many ways. And so that's something that would have to be taken into account or into consideration when developing a standard of care model. So if you're anticipating that a standard of care model would come in and say, okay, everything is standard of care or federal regulation, we'll just completely erase Pharmacy Practice Act and all of the regulations that go along with it, then we would essentially be relying on the federal regulations and then on whatever the standard is that we can prove in those industries in California. I don't know that that is what anybody is contemplating yet. I don't know that it isn't. It seems that the standard of care is being contemplated or considered more as a practice guide or a manner of practice for pharmacists specifically, for their clinical judgment, to allow them to be more of a part of the care team. And I think that's a positive. I think that there are some very careful language crafting sessions that would have to occur in order to sort of make that determination. But you are correct. I mean, compounding, sterile compounding, hazardous compounding, some of these really highly technical, even the controlled substance reconciliation, they have a lot of details, and our statutes and our regulations have a lot of details. And going to a sort of quote general standard of care model would obliterate some of those details. But that's one of the reasons I think this committee exists, is to discuss where that is appropriate and where that isn't appropriate, to try to draw some of those lines. Maybe a standard of care model is not appropriate. I'm saying maybe is not appropriate for a sterile compounding or hazardous compounding situation, but maybe it is for a hospital pharmacist who is consulting with physicians or oncologists, in that more, again, active practice setting. Eileen?
Yeah, I was just going to echo some of what Christina said. I think you hit some good topics, Dr. Serpa. I think as we start to drill down, or as this committee starts to drill down, it was kind of what I was trying to cover. Maybe it's trying to determine where you think a standard of care model would work and where it would not. And that's where the discussion can become, I think, potentially different. If they're just going to say we're going to obliterate all California laws with respect to all aspects of pharmacy and just go with the standard of care, that could be something that the committee would definitely want to look at, whether that would be appropriate in the lens of consumer protection in certain areas, or maybe have discussions, as Christina said, is it appropriate for compounding? Is it appropriate for storage, handling, and dispensing of drugs? Or is it more appropriate, where they're exercising clinical judgment? There are a lot of different ways, but I think the discussion will be guided about the scope of where stakeholders want to use a standard of care to replace existing California law, because it cannot replace the federal law that's already outstanding.
Thank
Nicole?
you.
I don't think I have anything to add. You guys covered it.
Thank you. Maria, did you have anything else? Just a reminder that this, and also hoping that our presenters, hoping you guys can also stay at the end of agenda item 5 after all the presentations, so that you guys could also I don't know if you would be allowed or not, but if you are allowed, I would love for you guys to be part of that discussion during that session. So hopefully y'all can participate then. I'm going to move on. Maria, did you have any other comments or thoughts?
No, just one thing for to share is to thank everybody for their comments, but also I would be interested in the comments of the other presenters for the different practice settings too, including that. That'd be helpful. Thank you.
Absolutely. And I hope that we will have that opportunity after some presentations. I'm going to go for Indira. Your hand is raised next. And I also see Dr. Shanes and then Nicole's too. Dr. Shanes will go to you after Nicole. So go ahead, Indira.
Thank you guys for that presentation. It was very, very helpful, and I really appreciated how you set up the regulatory model versus the standard of care model. And what I'm interested in knowing, based on your experience handling these cases, is what do you think the role of causation and harm, if it's different under that sort of regulatory model versus under the standard of care model? Where do you think that the standard of care model would result in discipline only if there's a showing of harm or causation of harm based on conduct? And is that, versus under the more regulatory type of model where discipline might be authorized in a wider range of circumstances, or maybe harm doesn't really play a role in either one?
Well, I can say that, most of our agencies don't require a finding of actual harm to a patient, but most of our agencies do require that the conduct was such an extreme departure that it could have resulted in harm to a patient. So in handling these cases, for example, for the Board of Registered Nursing, we don't have to show that the patient was actually harmed. We just have to show that it could have resulted in a harm to the patient. So I think, with regard to, moving towards a standard of care model, I don't think that that's something that we would necessarily have to show any kind of patient harm, but it would have to be an extreme departure from the standard of care that could have resulted. Christina, do you want to add anything to that?
Just a little, in that there is, in our experience, there's always the argument, right? Well, no patient was harmed by this, and so it was fine. That argument doesn't really usually get anybody anywhere, but it does frequently come up, and it comes up a lot less in the regulatory type model, because it really doesn't matter. If you violate a regulation, if you violate a statute, then the patient harm doesn't really matter. It's always it's always an argument. It's always something that we look at. It's always something that we do try to prove. We show either the patient harm or the potential for harm. But it's not necessarily, I wouldn't say, something that, like Nicole said, we don't have to prove it. And I think that it does become a lot less important in the regulatory model than in the standard of care, gross negligence, incompetence cases.
And to add on to what Christina just said as well, with regard to some of the regulations, I have found in my experience that it's been very helpful in presenting these cases at trial to explain kind of why the regulation is there, why it's important for public safety, why the board cares. And that way it just kind of provides some context for the administrative law judge who doesn't have a background in pharmacy or doesn't really understand, for example, a sterile compounding case, to explain to them, why we have these requirements for a master formula. It's really important to kind of get them to show them that, this is why we have these in place, and this is all of these regulations are meant to protect patients, protect consumers. And so again, we're not necessarily showing patient harm, but we're also showing kind of why we have these in place and what could kind of happen if we don't enforce these regulations.
Eileen, did you want to add anything? Are you good?
Hi, this is Eileen. The only other thing I was going to raise is as our newest member hasn't sat through an enforcement or some of the disciplinary cases, is our current disciplinary guidelines, don't require actual harm, but the potential for severe harm, and that comes into the level of discipline that may be imposed. Would you agree with that, Christina and Nicole?
Absolutely.
Absolutely. It is one of the factors.
Thank you. Indira, did you have any other comments or thoughts?
No, just thank you.
And an excellent question so far to our Vice Chair, Serpa and Indira. Thank you. And Nicole, go ahead.
Hi, yes, thank you so much for the presentation. That was very helpful. I can see some of the uses in this. I can see where a pharmacist is in a practice setting with other medical providers. This will make it easier for us to work in concert if they're working under standard of care and we are as well. I can definitely see that. But my question was about, our main purpose is protection of consumers. Do we have any information about it would be helpful to see health outcomes of patients under this, which maybe isn't really our scope, but also, with these other professions that have gone to standards of care, are we seeing more or less, disciplinary action taken against them? Like, what has been the impact on the protection of consumers in having this kind of model? I don't know if that's something we can speak to, but I think that would be really helpful to understand going forward.
I think that's a tough question because most of the agencies that we've discussed here and that Nicole and I are familiar with, it's not that they went to a standard of care model, it's that they have been a standard of care model, as far as I know, from the beginning of time, essentially, the beginning of my time anyways. So I really can't answer that question. I think it's an interesting question, and I would be interested to know the answer to it. Maybe something that we can look into and bring to another committee meeting down the line. But I can't answer that today. Eileen or Nicole?
No,
Yeah,
I would just point. Oh, go ahead, Eileen.
I think I was just going to point out some of the other presenters maybe hit on some of that. I believe Idaho and Washington have moved somewhat to a standard of care model in pharmacy, but I don't know the precise parameters about that, but there could be some information, from those states. But I think the other presenters may have some more information on that as well. And I don't know if Anne has any as well, but I do agree with Christina. It could be a good thing to look at going forward as the committee does its deep dive.
And the only other thing I wanted to point out was that, like the Board of Pharmacy, the mandate for these other agencies is also their primary duty is to protect the public as well. So they have the same mandate as the Board of Pharmacy.
Thank you. Okay, thank you. Nicole, did you have any other questions?
Not really a question, just commenting on that. Yeah, it might be helpful to look at, how many cases are brought for discipline from the Board of Pharmacy versus nursing versus medicine, these other places that use standard of care, like as a proportion of the people who are registered under those. It might just be an interesting area to look at. That might be a way that we can kind of get at some of this data to understand. Thank you so much.
Absolutely. Thank you. Thank you for a great question and comment, Nicole. Anne, go ahead. I see your hand raised.
Thank you, and thank you very much for the presentation. I was curious if you have any experience or are aware of how potentially standard of care is used where the licensee is potentially working in a site that is similar, that is also regulated, and where there may be potentially pressure points between maybe the facilities, policies, and procedures versus potentially standard of care model, if you have any thoughts on that. Thank you.
Christina? Or Eileen? I'm gonna pick on one.
I was gonna say, does Nicole want to try to address that first?
So, I mean, I'm not sure where I've seen cases where, for example, a hospital's policy or procedure was maybe like contrary to the standard of care. I suppose that could happen. But a licensee is always required to act within the standard of care. So if there, is, for example, a policy and procedure that's in place, that might be something that an agency will look at to see if that policy and procedure is within the standard of care. But it doesn't necessarily mean that the policy and procedure meets the standard of care. So a licensee is always, kind of required to meet that standard. I don't know, Christina, if you want to add anything.
Yeah, I'll jump in. So what I've seen in the past is in some of these cases is generally that the policy and procedure is, I would say, sort of expected to meet the standard of care, right? I mean, it's being imposed by a hospital or, other healthcare facility that has many, many nurses, many LVNs, doctors, et cetera. And so that policy and procedure is expected to essentially set forth the standard of care. It doesn't always happen. I've seen a few settings where patient ratios might be different than the policy or procedure. And in that case, if you have a statute or a practice guide that says that the patient ratio has to be, 2 patients for every 1 nurse, and then the policy and procedure says, we think we can get away with 4 to 1, then the policy and procedure is going to be deviating from what really is the standard of care in that practice setting. But for the most part, the policies and procedures do usually meet the standard of care, and in some cases set the standard of care. Because you're looking at a large healthcare system that has the same policies and procedures for multiple, hospitals throughout the state. And all of the nurses that work for those hospitals follow this policy and procedure. That in some ways creates the standard of care, because it is what any reasonably prudent practitioner in that setting would be doing, because that's what the policy and procedure says. So in some cases, the policies and procedures can actually, in some ways, sort of set, but also just outline and describe the standard of care. So that can be used in 2 ways in cases. One, it can be used to show that this, generally nurses, the Board of Registered Nursing is one of the largest agencies, and so we do get a lot of BRN cases. So I'm really kind of specifically referring to those. But we can show, hey, the policy and procedure says you have to do X, the nurse didn't do X, that could have caused patient harm, that is a deviation from the standard of care. It can also be used in some cases to say, well, this policy and procedure didn't specifically address this issue, but you might be able to have 3 or 4 policies and procedures that sort of surround the issue or give guidance to the nurse on how to handle specific issues. So it's almost more of an implication that these policies and procedures, sort of as a whole or a cluster around the specific issue, kind of set a standard of care. And then the other way that I've seen it used is to say this policy and procedure does not meet the standard of care. And the way that's usually used is by the respondent, because they have followed the policy and procedure. And we say, well, that doesn't meet the standard of care. The policy and procedure is wrong. And as a healthcare practitioner, you have a duty to follow the standard of care regardless of what your policy and procedure is. And at that point, their argument is, 1, if I don't follow the policy and procedure, I will be fired, which is, true. And it is a heartbreaking argument that does come up in some of these cases. But 2, how is the nurse to know that this is a violation of the standard of care if this is what their, large hospital system or large healthcare practitioner is telling them to do? They would assume that that is the standard of care because they wouldn't know necessarily any better. Which can be a very difficult argument to counter in the case of a disciplinary action. So I would say in general, in many, many ways, that policy and procedure is going to set the standard of care. Now, where it gets a little bit murkier is when you're talking about small entities, a single clinic that is just, self-owned, that has a policy and procedure that may or may not meet the standard of care. Well, that's one employer. That's not, 40 employers because it's this massive healthcare system. So the policies and procedures can set standard of care. They can deviate, but then they're very hard to argue against. But we always have to look at them. We always have to evaluate them. And we always have to have an expert that can review them and tell us, no, this is not within the standard of care, or yes, this is. And that's when, again, we get back into having to look at that expert's background. Does that expert have any background in this area? Have they ever worked for this employer? What do they know that addresses specifically this standard of care? And that's where you can really have to dial down and really get into the weeds of every specific, fact and issue that can come up. So I'm not sure that fully answers your question, Anne, because it was pretty broad, but hopefully that's at least a starting point on the discussion. Anything, Eileen?
No, I think you covered it. She was asking more for experience, and both of you have more experience dealing with the other settings.
Yeah.
Thank you. Thank you, Anne, for a question. Great question. And a reminder, we will have definitely more opportunity for discussion today. So hopefully all of you can stick around. So with that, any other member comments or questions before I open up for public comment? Reminder, this is just a public comment, just a ordinary public comment period. So, and then hopefully we'll have more opportunity for discussion later on. So any other member comment? Okay, moderator, please open the line for public comment. As a reminder, opportunity for more robust discussion on the overall topic will be later today. And if you wish to still provide comment on the presentation just provided, you may do so now. And this is for 2 minutes. And I see Rita, Dr. Shane's hand is raised. Thank you for being patient. And moderator, go ahead and open the line for Dr. Shane.
Thank you. This is the moderator. Our Q&A panel is open. If you'd like to request to make a comment, click on that Q&A icon, type comment into the text field, and submit that to our panelists. You may also raise your hand by dialing *3. First comment comes from Dr. Rita Shane. Dr. Shane, I've sent a request to unmute your microphone.
Thank you. I just wanted to echo the comments made by the board members. This was extremely invaluable information, really relevant. I think all of us in the profession would benefit from this sort of information. I had a specific question going back to Dr. Serpa's kind of comments with respect to work that's been done in the state of California to protect the public in the areas of sterile compounding and controlled substances. So one consideration, and I guess I wanted to get your perspective, there are national standards for both of these. So for example, USP has continued to promulgate and is updating their standards with respect to hazardous and non-hazardous compounding, as well as non-sterile compounding. And again, those are about to be revised. It'll probably take a while to get them, but there are existing standards, and there are also national kind of best practices through our national professional organizations for health system practice, which is where I practice. There are standards around controlled substances management to ensure accountability and, of course, compliance with federal regs, which we totally understand. Those will always be part of what we need to do as in the practice of pharmacy. So my question is, if there are existing national standards and guidance from bodies such as USP and or professional organizations that actually do extensive vetting and get lots of professionals involved in determining best practices around what we're calling high risk processes and to protect patients, would those be considered a way to ensure standard of practice? So I wanted to just ask that question.
Thank you. And not seeing any other requests for comments on this presentation. Would you like me to close the panel?
Thank you.
I
And
think- I'm sorry, we do have one more request that just popped in from Michael Mattis. Michael, I've sent the request to unmute your microphone.
Hi, good morning again. Can you hear me okay?
Good morning. We can.
Yeah, okay. I've really enjoyed this presentation. Thank you so much. My comments are that I'm a pharmacist for 40 years, and I've worked in lots of different practice settings. And I totally agree to try to adopt standard of practice model for even the number of practice settings I've worked in would seem to be a daunting task and very difficult to be consistent. And then if a pharmacist would, because there are several pharmacists I know that work in different practice settings, they would have a hard time going from one setting to the other if those kinds of standard of care guidelines were adopted. But pharmacists are referred to as practitioners, not technicians. We're not vending machines. There's nothing simple about this profession at all. We also have a corresponding responsibility with prescribers. And I think pharmacists are generally trained and think in a black and white fashion. I think if we adopt standard of care guidelines, management, or if you work for a large company or a small company, management would then push you to follow their standard of care. And it would then take the practitioner out of us, out of the practice would be out of the practitioner when you don't have that ultimate decision to make about how you're gonna pursue something. So I thank you for your time.
thank you. Presenters, I'm gonna actually give you opportunity if you want to respond to either commenters, questions, or we could do it later.
Hi.
Yeah.
This is I actually think it might be better to do it later because otherwise then we open it up for public comment again on what our presentation is. I think some of these matters, unless Christina and Nicole feel differently, may be touched on, with respect to the next presenters, and maybe we talk about that in connection with item 5.
That sounds good to me, Eileen. So Dr. Shane, hold that question and just please be sure to bring that up during agenda item 5. And also I apologize, due to some scheduling conflict, I'm gonna have to take things out of order. So presenters, Nicole, Christina, Eileen, thank you so much for the presentation. We really appreciate your time.
Thank you for your attention.
Thank you.
Thank you. And we can turn off our cameras at this point, correct, President O?
Yes, that's okay. All right, so next is agenda item 4, but I'm gonna have to go to agenda item 5 for one presenter. We're taking presentations out of order. So one of the presenters, Jazzy, has a conflict. She has to leave very soon. So we're gonna give her the opportunity to present. Shelley, if you could please promote her to the presenters. And if we can go to her next. Jazzy, let us know when you're ready, and the floor is yours.
Can you all hear me?
Yes,
We can.
Thank you.
Wonderful. And I believe my camera should be working. Great. Thank you all for being so flexible and allowing me to go out of order. I apologize for a previous conflict that I did have, but appreciate the opportunity to testify today. So good morning, Chairperson O, committee members, and Board of Pharmacy staff. My name is Jassy Graywall, Legislative Director with the United Food and Commercial Workers, UFCW Western States Council. UFCW is a private sector union with over 180,000 members in California and 1.3 million members countrywide. UFCW represents various types of workers, including pharmacists, pharmacy technicians, pharmacy interns, and pharmacy staff in the grocery and drug retail settings, otherwise known as community pharmacies. Our members tend to work at the big drug retail chains like Rite Aid, CVS, Walgreens, and large grocery chains like Kroger, Albertsons, Safeway, Ralph's, Raley's, and Vons, to name just a few. We appreciate the opportunity to present today to provide our perspective on California moving from a hybrid structure that currently incorporates both state and federal laws and regulations and standard of care provisions to a solely standard of care model. While UFCW is still assessing the benefits and drawbacks of a standard of care model, our presentation today will raise 2 items board members and Board of Pharmacy staff should consider when making the determination of whether a standard of care model is applicable across all pharmacy care settings in California and a UFCW recommendation. First, the imposition of discipline against a pharmacist based on a standard of care must be predicated on the fact that community chain pharmacists work for vast publicly traded corporations under dramatically different daily conditions than those who work for independent pharmacies. Second, our member pharmacists support any effort to improve the care of their patients, but we must acknowledge the working conditions of our members. UFCW will respectfully recommend that the Board of Pharmacy, through this ad hoc committee process, assess how the development, adoption, and implementation of a standard of care model impacts each specific care setting, particularly community chain pharmacies, due to each setting's unique circumstances. So first, the imposition of discipline against a pharmacist based on a standard of care must be predicated on the fact that community chain pharmacists work for vast publicly traded corporations under dramatically different daily conditions than those who work for independent pharmacies. Unlike other medical professionals and other pharmacy care settings, in community chain pharmacies, pharmacists, pharmacy technicians, and pharmacy interns have a unique relationship with their employer. Community chain pharmacists are under the strict control and direction of an employer who is not a licensed pharmacist, but is a publicly traded corporation. And publicly traded corporations are beholden to their stakeholders and must show value year after year by being profitable. Now compare this to independent pharmacies, who are owned by a licensed pharmacist and are not publicly traded. Pharmacists at an independent pharmacy are at the discretion of a licensed pharmacist, where pharmacists at a community chain pharmacy are at the discretion of a corporation. While both of these are community pharmacies, there is a stark difference between the employee and employer relationship. This is even more evident in the workforce survey results that were released by this board and presented at the Medication Error Ad Hoc Committee. Which brings me to my second point. Our member pharmacists support any effort to improve the care of their patients, but we must acknowledge the working conditions of our members. Conversations on adopting a standard of care model cannot happen in a silo or a bubble. It is important to understand the realities and real-world circumstances that pharmacists face when considering if and how California should move towards a standard of care model. In a perfect world, pharmacists would be able to solely provide direct patient care services that would improve access to healthcare, reach and service geographically and medically underserved communities, and provide preventative health services. But unfortunately, we don't live in a perfect world, and retail pharmacists have been sounding the alarm bells on their working conditions well before the pandemic, and this pandemic has even further exacerbated those working conditions. The workforce survey revealed what our pharmacists have been telling us for years, that pharmacists in community chain pharmacies are overworked and understaffed. The results showed that pharmacists at chain pharmacies fill more prescriptions and are required to provide more services at a higher rate than their counterparts at independent pharmacies. 78% of chain pharmacists said they did not have adequate time to screen patients, be providing immunizations, compared to only 44% of pharmacists at independent pharmacies. 97% of chain pharmacists are required to complete non-dispensing related duties by their employer, compared to only 72% of independent pharmacies. Both chain and independent pharmacists reported that only a little over half of medication errors are properly documented, consistent with the board's quality assurance requirements, with chain pharmacists reporting higher medication errors happening in a month. And 91% of chain pharmacists said staffing at their worksite was not appropriate to ensure adequate patient care, compared to 37% of independent pharmacists. While the state should act prudently in the protection of public health, it is important to remember that pharmacist protections are patient protections. If pharmacists do not have adequate staffing levels and safe working conditions, the ultimate result is harm to patients. We cannot improve patient care without improving pharmacist working conditions. A standard of care model would broaden the pharmacist's scope of practice, which would impose additional workforce stress on an already overwhelmed workforce. Last year, with the support of this board, the legislature passed and the governor signed Senate Bill 362 by Senator Newman, which prohibits chain community pharmacies from imposing quotas on prescriptions and services rendered by pharmacists and pharmacy technicians. This bill was in response to the practice set forth by community chain pharmacies that require pharmacists to meet profit-driven quotas, like filling X amount of prescriptions in a day or week, or administering X amount of vaccines and tests, in addition to other quota requirements. These quotas were not centered in patient care, but to drive profits to the company. Under a standard of care model, where scope of practice would be broadened, what additional services would corporations push pharmacists to administer related to profit drivers? The legislature and the board cannot account for all the ways in which corporations would use a standard of care model to push pharmacists and pharmacy technicians to do more without adequate staffing and working conditions, particularly in our low volume pharmacies where there is only one pharmacist working a 12-hour shift alone, filling prescriptions and rendering services, an impossible task for one person. Now, why does all of this matter? As the Attorney General's office mentioned, standard of care is the treatment that another reasonably prudent practitioner in a similar setting would give to a patient. It is objective. Depending on the care setting, and even within that care setting, the treatment that another reasonably prudent practitioner would give a patient could vary drastically depending on the direction that publicly traded corporations take to maximize profits. While a standard of care model could be more flexible for specific situations, and the legislature and this board would not need to update laws and regulations frequently to keep up with the evolving practice, industry and corporations would then be setting the standard of care for pharmacists, which is ultimately motivated by profits. A standard of care model does not explicitly state what pharmacists can and cannot do and how they would be held accountable for standard of care violations. This lack of consistency would create different standard of care standards, not just across various practice settings, but also across different community chain pharmacies who have competing interests. Furthermore, standard of care would completely sideline the reasons why the legislature has adopted specific requirements, such as pharmacist and pharmacy technician worker protections. While the legislative and regulatory process can be time-consuming, it provides clear guidance on what is and is not allowed in the practice of pharmacy. This is critical for pharmacists to understand what their responsibilities and rights are at the workplace to prevent employer overreach. This legislative and regulatory model also provides consistency of standards across employers in the state and allows the public, including licensed professionals, to engage in the rulemaking process, which is paramount to incorporating the realities in the profession. UFCW understands the crisis on the horizon, an aging population and an increasing population living with chronic conditions. There will be a need to fill the physician shortage. However, as you consider moving to a standard of care model, UFCW urges you to consider the issues pharmacists are facing in the community chain pharmacy setting that need to be addressed. Without addressing these issues, UFCW is concerned that a standard of care model will further exacerbate these problems, causing undue harm to pharmacists and patients. There is a reason that California has the highest patient safety standards in the country. It is for these reasons and more that UFCW respectfully requests that this board, through this ad hoc committee process, discuss the impacts of adopting a standard of care model for professionals at community chain pharmacies, including discussions on the impact to low volume pharmacies. Thank you for allowing me to provide public comment at today's ad hoc committee. I'm happy to answer any questions that committee and staff may have when appropriate. And thank you again for allowing me to go out of order.
Thank you. Thank you so much, Jazzy. Thank you for the presentation. Members, did you have any questions or comments for Jazzy? Before we let her go ahead and raise your hand if you do. I don't see anyone. Okay, thank you so much, Jazzy, for the presentation. All righty, we are going back on agenda item 4, and that is presentation on standard of care, including the task force report released by the National Association. Sorry, Eileen, go ahead.
Hi, this is Eileen, that we're going to have comments on Jazzy's presentation with all the other item 5 presentations,
Right.
Correct?
Right. Yes.
Thank you.
Yes. Yep. Presentation on standard of care, including the task force report released by the National Association of Boards of Pharmacy and National Perspective. I welcome Bill Cover, Association Executive Director, State Pharmacy Affairs with the National Associations of Boards of Pharmacy, NABP. Mr. Cover, thank you very much for your time today, and I will turn the floor over to you for the presentation.
Thank you very much. I appreciate the opportunity today to speak with you all about this very important topic. My name is Bill Cover. I'm the Associate Executive Director of State Pharmacy Affairs for NABP, the National Association of Boards of Pharmacy, in which the California Board of Pharmacy is an active member. With that, I'll just like to reiterate our mission again, as we really are the association of our members, which is all of the state boards of pharmacy across the country, as well as some international partners that are focused and aligned with California Board of Pharmacy mission of protecting the public health. I just wanted to kind of reiterate that. In addition, I spent 10 years on the Indiana Board of Pharmacy, and so I definitely understand hard efforts of you all that it takes to protect the public when it comes to the profession of pharmacy. So thank you for your efforts on behalf of your citizens of California. With that, I just want to, I guess one of the asks of me is to really describe where our association is, some of the efforts that are brought about and drive our association by how we support our member boards. And one of those was at our annual meeting in May of 2018, in which a resolution listed there that was brought to the full membership for one of the districts. We have district meetings, and those resolutions are developed in those district meetings and brought to the full body that represents all of the member boards. And at that meeting in May of 2018, the resolution, which was titled Task Force to Develop Regulations Based on Standards of Care, was approved, again, by the full body. And I think it describes there, again, what the resolution of therefore be resolved, that resolution describes. And so with that, I'll move on. So again, based on that resolution passing, we held a task force in October of that same year. And again, these task force have representatives from across the entire country. And so part of that group, and I believe Dr. Robinson, who came here soon, was also part of this task force, came up with 5 recommendations. The first of all being for NABP to encourage member boards to review the practice acts and regulations and determine, which are no longer applicable, and also how those could be revised or eliminated as practice continues to evolve. Second recommendation was for NABP to encourage our state boards of pharmacy to look at, are there regulatory alternatives, specifically around clinical care services that, again, can allow pharmacy professionals to be regulated more on the standard of care model. Third recommendation was for NABP to collaborate with states that may look at adopting these standards of care and identify and monitor and how they disseminate those outcomes. Fourth recommendation was for NABP to develop a definition of standards of care to be included in our Model Act. And finally, the recommendation number 5 was continue to monitor the adoption of states, and as they're looking at considering this type of regulatory model and assisting them. And I guess today is a good example of that recommendation of the task force. So specific, to that task force and that recommendation number 4, which was to, again, modify the NABP Model Act That went to our Law Enforcement and Legislation Committee, which met on in January of 2019. And we adopted an amendment, and which was formally adopted in August of 2019 by our executive committee. And you can see below what the definition, again, of standard of care that's been included now into the Model Act. Again, that's been there since August of 2019. So just, I think it was mentioned earlier that, again, a couple of states that have really kind of, I would say, pioneer or at least in the pharmacy practice world, moving in this type of direction. And Idaho was very much the tip of that spear, and really significantly reduced the level of prescription regulation in practice throughout their Practice Act. So that was significant movement there, as well as in Washington more recently. They also looked at using much more broad language that again leaves it more to the practitioner and the healthcare facilities to be able to determine how to deliver pharmacy care to patients in a safe manner, but in potentially a different way based on things that are enabled by new practice standards or technology. As well as these states really looked at, again, enabling those things to occur more easily. So those states, again, took an approach of really a complete rewrite of their practice acts in a significant manner, just kind of starting over and looking at every aspect in a different way. Again, these states still do have some prescriptive regulatory sections that I say are more reflective of some of the facility, and obviously prescription drugs are something that we manage and have to ensure are handled in the right way and are applicable by the state and federal laws. So pharmacy, I think, has some unique parameters compared to other health professions that don't have that possession of the drug product potential, and part of why in some cases our regulations are more lengthy and depth than some of the other healthcare professions. So again, getting back to the standard of care as it reflects in Idaho, this is the definition that in rule that was again for you to be able to read through and get that perspective, as well as Montana also placed this in their definition sections and within rule to establish again what a means by which they can refer and utilize in other areas of their regulations, as well as potentially their administrative code, if there's a finding of deviating from those standards of care. I'm going to go through a few of the states here now that have incorporated the standard of care definition a little differently from the broad rule and statutory rewrite of Idaho and Washington, but some have made kind of their first entry into this area as it applies to more of a disciplinary type of approach and utilization of defining standard of care. Again, Idaho, in addition to what I described earlier, does have that again in their section of code that defines standard of care and then gives it an enforcement ability for their Attorney General's office to bring if there's a situation of potential deviation from that standard. The state of Ohio also has several sections, one more broad in the first reference, and then more specifically under immunization administration, defined as failed to conform to prevailing standards of care. Again, as far as what potentially for disciplinary action potential. Wisconsin similarly defined in their administrative rules, as far as defining a potential for disciplinary action that practicing in a manner which substantially depart from that standard of care. A little more detail to the state of Washington, which I described earlier. You'll find this on their website, but they also define practice standard of care, but also have this this chart that is not only applicable to the pharmacy practice, but is across the Department of Health in the Washington State that regulates a large number of health professions, similar to DCA California. But this chart and descriptors that here again are applicable to all those regulated under that Department of Health in Washington State. Some other approaches that we've seen in other states is North Dakota, which included in its rules pharmacy patients' bill of rights, again, to have professional care that's done with the accepted standard pharmacy practice. In Delaware, slightly different model in which they incorporated this into their pharmacists in charge responsibilities, again, to establish those procedures that maintain standard of practice. And I think that was something that was probably discussed just recently with your Attorney General's office. I think that's something you might all want to look at in the state of Delaware. But as far as, again, some of the, that task force in 2018 and then adopting of those changes in 2019, we really saw a number of states looking at this type of change, different type of regulatory scheme. And then COVID-19 pandemic, and I think it really, obviously the priorities and board and staff, everyone, including practitioners, our focus was taking care of people during the public health emergency, as well as working through allowances of under executive orders, the Federal PrEP Act. And so that, I think, is one of the major impacts of not seeing additional movement with other state boards of pharmacy. But I think the interest is still very much there and will, again, kind of be reignited, once our, bandwidth and ability as board members, staff, and Attorney General's office are able to spend more time in this very important task. But currently, we're not tracking any legislation relative to standard of care and the practice of pharmacy. So predominantly, most states are in the first quarter of this year. I know California has a longer legislative session, but again, we're not currently at this time tracking any that are specific to standards of care in pharmacy. And I think that's the other impact of this that you all are aware and already discussing. That is a significant investment in time and effort by everyone involved to do this in a manner that is impactful for patient, that not overly burdensome for providers, that could eventually have impact to patient care as well. So I think that that's an important, thing to take in mind. But the other thing that I can talk to is briefly is that there's a varied level of what they're looking. I think what I'm hearing most from the states is that they're interested in what you all are describing of the applicability of this to that clinical pharmacy practice sections of the practice acts or various things, and not so much, again, taking out, their entire practice act that in some of those aspects are more around, again, facility, drug component, how we manage other aspects of pharmacy practice outside of those clinical pieces. So I think that is something to make mention, as well as Idaho is, I would say, is a little bit more progressive in the manner in which they've stated they really wanted to set the parameter of permissionless innovation, in which they really have clearly indicated that basically unless expressly prohibited, it is allowed. So I think that is a again, some states are different in the way they apply that. It's more expressly prohibited unless allowed. So I think that's important to note. And also, some states are very much open to some of the practice standard of care model that might allow for practice expansion, scope, different things that pharmacists can do to better impact patient outcomes. But when it comes to technologies that in some cases are part of those solutions, that's a crawl, walk, run approach that they're gaining some more knowledge, and that's the thing I think all state boards deal with are constantly evolving level of technology that can be part of those new practice models. I think that is something that I think that we've seen some of that play out during this public health emergency, and seeing some states that are kind of looking at things in a different manner following the public health emergency, and what we've seen and some of the impact those things can have that have been done under executive order, state executive order, or the federal PrEP Act. So that with that, I will leave to again questions that we can look to after the other presenters. So thank you again for the opportunity to present.
Thank you so much, Mr. Cover, for the informative presentation. So members, same thing. Any questions or comments, please raise your hand. Okay, I don't see anyone raising a hand. Thank you again, Mr. Cover, and hoping that you could stick around for the discussion. So we'll be having that after agenda item 5, after all the presentations are done. Hopefully your time will allow you to stay on so that you can be part of the discussion.
Thank you.
Thank you so much. Okay, so, and then moderator, please open the line for public comment for Mr. Cover really quick.
This is the moderator. Our Q&A panel is open. If you have a comment for Mr. Cover's presentation, please use that Q&A panel to submit the word comment to our panelists. You may also raise your hand for our calling users by dialing *3.
I don't see anyone, and
so Jessica Crowley had chimed in with a comment prior to going to Mr. Cover's presentation. Did you want to hold hers till we get done with item 5?
yeah, let's do that. Yeah.
Okay. I'm not seeing any requests for comment for Mr. Cover's presentation.
Okay, thank you. Thank you so much, Shelley. I think it is time to take a quick break. We've been going at it for a couple hours, so if we could take about 10-minute break, we'll be back at 11. Let's do 11:15, 11:15, and we'll get back on agenda item 5, go with the presentation, probably take a lunch break around after first couple presenters, and then we'll get back for the discussion. So we'll see you back at 11:15, 11:15, I'm sorry. Everyone is back. Or take a quick
This
roll
meeting
call.
is being recorded.
Okay, Maria, are you back?
I'm back. Thank you.
Thank you, Maria. Indira, are you back?
Yes, President.
Hi, thank you, Indira. Nicole, are you back?
Yes, I'm here.
Thank you, Nicole. Okay, all right. So we're going into agenda item 5, presentations and discussion on standard of care enforcement model. As you may recall, as a precursor to the meeting today, the board invited stakeholders to provide a presentation during the meeting today. Individuals that indicated an interest were requested to limit their presentation to about 30 minutes, followed by a Q&A session. Where presentation slides were provided, the slides were provided to members and posted on the board's website. As I stated earlier, following these presentations, we will be opening up the meeting for larger discussion. As such, to facilitate this portion of the meeting, following each presentation, we will provide members with an opportunity to ask questions. After all of the presentations, we will open up for the discussion. During this period, individuals will have 5 minutes to provide comments on the presentations and general comments. We will allow individuals to comment more than once and respectfully request that individuals re-queue or raise hand in the Q&A section so that you can comment or respond to any questions or comments raised, including what was raised during the day today in the first 2 presentations. I will remind everyone again when we begin this discussion, and also a reminder, Jazzy was part of this presentations and she did already give her presentation. So our next presentation is from Dr. Danian Robinson. Dean Robinson, welcome, and the floor is yours. Thank you for coming.
Well, thank you very much. And I do want to thank the board for dedicating a significant amount of time discussing this subject and for assembling a great group of speakers. It's all been very, very informative. Just a slight correction, I'm a professor at College of Pharmacy at Western University of Health Sciences, and I am representing the California Advancing Pharmacy Practice Working Group. Next slide, please. So my reason for an interest in standard of care, I have been involved in the policy committee for the American Pharmacists Association, and in a meeting that will occur at the House of Delegates later in March, there will be a policy statement moving forward, a policy proposal, standard of care regulatory model for state pharmacy practice acts. So they're very interested in this subject. As Mr. Cover mentioned, I was a member of the NABP task force to develop regulations based on standard of care. And I represented the American Association of Colleges of Pharmacy in my capacity at that meeting. And I have been chairing this working group, and I will acknowledge members of the working group after at the end of my presentation. I want to start by mentioning that all pharmacists take an oath of the pharmacist, and they essentially do it twice. They do it at the beginning of their educational programs, so that as they're going out as licensed interns, they have gone through the oath of a pharmacist, and then it's done again following as part of commencement. After they've finished their educational requirements and before licensure. And they once again take these vows. So it says, I promise to devote myself to a lifetime of service to others through the profession of pharmacy. Then there's several vows that are given, and it ends with, I take these vows voluntarily with the full realization of the responsibility with which I'm entrusted by the public. So the there is a social contract created by stating these vows and stating the oath. And this happens for all health professions. So they all go through something similar to a white coat ceremony, and they all say the oath of their profession on graduation. And by doing so, they promise to provide altruistic service, to maintain professional competence, and maintain moral integrity and morality and integrity. So the profession's right to self-delegation really has been delegated by society, by federal and state legislation, through boards of medicine, pharmacy, dentistry, and other health professions. So what boards do is they set standards for education, training, and entry into practice. They regulate practice, and they ensure standards are met. And we heard several areas of a lot of discussion about this regarding discipline responsibilities for unethical, immoral, or incompetent practice. So we will be talking about this in just a moment, about the importance of self-regulation within pharmacy. SB 493, which was sort of landmark legislation for pharmacy in California, declared that pharmacists are healthcare providers. So thank you for advancing the slide. However, the bill did not make conforming or technical changes that would allow pharmacists to fully function as healthcare providers. Next slide. So what was missing? So existing language in the Business and Professions Code was implemented before legislature declared pharmacists as providers. Many of these rules and regulations have been on the books for many years prior to that change that was implemented in 2014. And the legislation put into statute many decisions that probably should have been at the provider's discretion. So I'll cover a couple of those on the next few slides if we go forward. Thank you. So here's some examples of statutory handcuffs that were created. So pharmacists, according to the Business Professions Code, are authorized to provide self-administered hormonal contraceptives. But it does state that the Board of Pharmacy and the Medical Board of California are both authorized to ensure compliance with this subsection. So here, the Medical Board of Pharmacy is involved in sort of the regulation of pharmacy as it relates to hormonal contraceptives. And it also goes on to say that the pharmacists may furnish according to standard procedures and protocols that are developed and approved by the Medical Board and the American Congress of Obstetricians and Gynecologists. So as has been pointed out several times earlier today, these statutory changes are very time consuming. So if there was a change in sort of a standard of practice or current understanding, current evidence-based practice, it would take statutory change to make those changes rather than doing something fairly quickly. Another example on the next slide is naloxone. So pharmacists may furnish naloxone in accordance with standardized procedures and protocols developed and approved by both the Medical Board of California in consultation with the California Society of Addiction Medicine. Again, any changes, changes in dosing recommendations or new products that come out in a relationship to drug overdoses, that would have to take an additional statutory change. On the next slide, HIV pre-exposure prophylaxis. Again, pharmacy board shall consult with the medical board. And it says, as well as relevant stakeholders, not defining who those might be, but not limited to the Office of AIDS of Public through the Department of Public Health. And next slide, please. As it relates to vaccines, pharmacists were previously authorized to administer vaccines. When the COVID vaccine was developed, again, and everybody here that was involved in treatment and management and distribution of vaccines and testing realizes we once again had to change the law in order to add an additional vaccine. There was no corresponding change required for medicine because change is inevitable and constant. In healthcare, things continue to evolve continuously. So, the next slide. So what we're suggesting is that we need to sort of face this delegated self-regulation head on, and we would like to recommend a change to pharmacy law such that no state agency other than the Board of Pharmacy may define or interpret the practice of pharmacy for those licensed pursuant to the provisions of this chapter, or develop standardized procedures or protocols pursuant to this chapter. So that would, in fact, remove some of these regulatory handcuffs. In the NABP Model State Pharmacy Practice Act, Section 212 empowers boards to make such rules as are necessary to fully administer and implement the act with the greatest possible flexibility and autonomy. Next slide. If you were to look at the guidelines for structure and function of state medical and osteopathic boards, it does say that the Medical Practice Act should provide for a separate state medical board acting as a governmental agency to regulate the practice of medicine. Furthermore, the Medical Practice Act should not apply to those practicing dentistry, nursing, optometry, psychology, or any other healing art in accord with and as provided by the laws of the jurisdiction, which in that case would mean of the individual states. So there is precedent for this type of language within the Business Professions Code. Nursing Scope of Regulations in 2004 says that no state agency other than the board may define or interpret the practice of nursing for those licensed pursuant to the provisions of this chapter. Respiratory therapy in 2019, except for the Respiratory Care Board, the state agency may not define or interpret the practice of respiratory care for those licensed pursuant to this chapter. Now on the next slide, there is a difference between professional scope of practice and legal scope of practice. Professional scope of practice really, relates to the services that are provided by members of that profession who are trained and competent to perform those services. And it evolves to integrate new developments, new knowledge and skills for the profession. But what we're dealing with in pharmacy and in terms of scope of practice, we're dealing with state laws and regulations that define services that may or may not be provided by a profession. So next slide. So changes to legal scope of practice require legislative and regulatory action, which are slow, adversarial, and costly. And we have an entire article within Chapter 9 of the Business Professions Code, Pharmacy Scope of Practice and Exemptions. And there's really no comparable language in the Medical Practice Act. In fact, the term scope of practice doesn't appear in the Medical Practice Act. Next slide. A case in point, when in 2010, when the Affordable Care Act was implemented, the goal was to enroll an estimated 30 million Americans in health insurance and support innovative ways to organize and deliver care. And part of that innovation was to enhance the ability of multidisciplinary teams to work together based on the needs of the population. But one of the problems that was encountered in developing multidisciplinary teams if every state has legal scope of practice restrictions built into their laws, it's very difficult for multiple health professions to work together efficiently. And you have to do it sort of one state at a time. Standard of care could resolve some of those issues and move things much more quickly. So our goal would be to move from a legal scope of practice to a standard of care regulatory or enforcement model. So create a regulatory environment in California that maximizes the ability for pharmacists to function as healthcare providers. And that would be similar to models that are used in medicine, nursing, dentistry, and others. Next slide. As the pharmacists in today's session are well aware, pharmacy has undergone amazing transitions over the last 60 years. And it used to be very much product-based, and really all of our educational, or much of our educational focus is much more on patient care. And that transition has been just continues to accelerate as pharmacists assume greater and greater roles in the healthcare as healthcare providers. Pharmacy practice is very diverse. According to the healthcare provider taxonomy, and this is developed by the National Universal Claims Committee, which is hosted by the American Medical Association, but works very closely with CMS. Pharmacists provide acts or services necessary to provide medication management in all practice settings. So that's an example of what we're talking about, is really providing medication management and preventative healthcare services. Next slide. If we were to look at NABPLEX, which is the National Pharmacy Licensure exam, there are 43 competencies listed, and they're all listed here. There's 6 different domains, and on the next, I'm not going to go through these individually, but if we go to the next slide, you'll see that all the area 5, which is compound, dispense, administer drugs, and manage delivery systems, are really focused on the assessment, monitoring, and treatment of disease. That's drug selection and dosing, disease prevention, and interdisciplinary practice. So that's 37 out of 43 of those competencies are really based on patient care, and as opposed to drug distribution, drug systems, and drug and distribution facilities. Next slide, please. The Accreditation Council for Pharmacy Education, according to the standards 2016, and they're currently in a revision process right now, but it requires that that pharmacy school graduates are ready to provide direct patient care in a variety of healthcare settings, so they are practice ready and contribute as a member of an interprofessional collaborative patient care team. So they are also team ready. Next slide. So a license to practice nursing, dentistry, medicine identifies the licensee as possessing foundational knowledge and skills and abilities to practice that profession. So I do want to emphasize that we're talking about foundational knowledge, skills, and abilities. Now, if you were to look at the American Board of Medical Specialties, they recognize 40 specialties and 87 subspecialties. And the Board of Pharmacy Specialties recognizes 14 specialties. So if we look at the graphic on the next slide, this is an example of how the medicine uses a standard of care model. So everything to the left of that vertical line, so that vertical line represents the Medical Practice Act. So those are all the foundational knowledge, skills, and things that are necessary to practice medicine that are foundational. Yet we all know that with all the specialties in medicine and subspecialties, that it takes additional qualifications to practice those. And there's nothing written in the Pharmacy Practice Act that distinguishes what a family medicine practitioner does as opposed to an oncologist or an orthopedic surgeon or others. So all of those differences in licensees who have additional qualifications are really regulated under a standard of care model. So a physician who receives a quality of care complaint would be reviewed by a medical expert or experts with pertinent education, training, and expertise specific to the standard of care issue. And under section listed here in the Business Professions Code under enforcement, it describes the enforcement model for medicine based on standard of care. Now, this is a hypothetical graphic because it doesn't currently exist, but this is what it might look like for pharmacy. So everything to the left of that would be foundational knowledge, skills, and things that pharmacists, a graduating pharmacist, needs to be able to do. And then with additional qualifications, you'll find that it varies depending on what their specialty is. So someone who's a geriatric specialist versus a cardiology specialist, or someone who specializes in AM care, certainly has additional qualifications. And the authorities that they have under the additional qualifications that allow them to practice at that level should be regulated under a standard of care model. Now, there's the length of these arrows, really is irrelevant. Community pharmacists, there are many community pharmacists who practice at a higher level in California because they're providing additional services over and above what is the foundational knowledge. For example, community pharmacists providing travel medicine services would have additional training, education, certification, and be very current on the issues related to providing care for travel medicine. So, this is what the model might look like, and in that case, the pharmacist who receives a quality of care complaint would be reviewed by a pharmacy expert or experts with pertinent education, training, and expertise specific to the standard of care issue. Next slide. So under the new regulatory model, pharmacists providing healthcare services would be held to the standard of care that would be provided in a similar setting by a reasonable and prudent licensee with similar education, training, and experience. So, and let me, on the next slide, we list the advantages of the standard of care model. It utilizes the full competence and ability of the health professional, is determined by education, training, and experience. It recognizes professional heterogeneity. It advances with new education, technology, science, and practice standards. And it avoids tying fixed regulations to an entire class of health professionals. It also avoids lengthy statutory and regulatory changes as practice and healthcare evolve. So I mentioned that there's a policy statement coming from APHA, and part of the policy statement says that APHA requests that state boards of pharmacy and legislative bodies regulate pharmacy practice using the standard of care regulatory model similar to other health professions, thereby allowing pharmacists to practice at a level consistent with their individual education, training, experience, and practice setting. So practice setting is very important, and I know that's been raised by a number of people this morning. If you happen to be in a practice setting that doesn't support a level of service based on your additional qualifications, then you wouldn't, that's not something you would be doing in that practice setting. So if an employer decided, oh, we're not going to be providing that particular service, you're not going to provide it if it's not supported. Part 2 of the policy statement says, to support implementation of standard of care regulatory model, APHA reaffirms the 2002 policy that encourages states to provide pharmacy boards with the following: adequate resources, independent authority, including autonomy from other agencies, and assistance in meeting their mission to protect the public health and safety of consumers. And this was just covered by Mr. Cover, so I don't think I need to repeat that, but it does say what the recommendation was from NABP regarding regulatory alternatives for clinical care services. So there was quite a discussion at the NABP task force, and many people favored the fact that we should not try to apply standard of care regulations to facilities, or there's many things that are sort of bright line regulations that need to be followed regardless, and it shouldn't be held to a standard of care model. So as one of our previous presenters mentioned, that they were opposing a full standard of care approach to regulation for pharmacy. That is not necessary. What this is talking about is more related to those patient care services that pharmacists are now able to provide. So some questions that may arise. Would all licensed pharmacists be able to provide the full scope of services under the standard of care model? And the answer is no. Only those who have the education, training, experience, and they're in a practice environment to provide the service or activity that supports that service or activity. Next slide. Is there a credentialing process for pharmacists? Well, yes. Pharmacists maintain a record of their credentials, which would include license, residency certificate, board certification, continuing pharmacy education, and training certificates. And APHA actually has a fairly comprehensive verification system called pharmacy profiles that could be used by employers and healthcare systems to verify a pharmacist's credentials. Next slide. Should pharmacists be required to follow clinical practice guidelines? Well, the answer is no, because science, healthcare delivery, and evidence-based practice are continually evolving. At one time, there was the Agency for Healthcare Research and Quality National Guideline Clearinghouse. However, in 2018, they had over 8,000 guidelines. And many of these guidelines were developed contemporaneously by sort of different people developing guidelines that were often in conflict. The guidelines were not necessarily, didn't have the scientific rigor behind them that would have been supported. And some of them were actually developed by pharmaceutical companies or other agencies that had sort of a self-serving agenda. So that agency was actually defunded in 2018 because of its limited usefulness and the impossibility of trying to keep guidelines current. So that's probably not something we would want to follow. Next slide. Do we need pharmacists to play a greater role in medication management? Well, yeah. So all the health professions, pharmacists have by far the greatest understanding of drugs, drug selection, drug management, and their safe use. And there's over $500 billion in avoidable spending that is attributed to suboptimal use of medications in the United States. And we know that as pharmacy is allowed, a larger and larger percentage of pharmacists they're not dispensing drugs, they're dispensing information and they're providing patient care services. So there's the standard of care model applies beautifully to those who are providing direct patient care. In summary, implementation of a standard of care regulatory model for pharmacy practice would improve access to healthcare services, promote health equity within geographic or medically underserved communities, and remove unnecessary barriers between patients and vital medication management and preventative healthcare services provided by pharmacists. On the next slide, I want to recognize members of the Advancing Pharmacy Practice Working Group. It's throughout the state, our different professional organizations are represented. We had the former Rear Admiral, Assistant Surgeon General involved. And we've been working on these issues for about the last 3 years. So with that, I would be happy to answer any questions that you might have, or we can hold the questions until the final discussion.
Thank you, Dr. Robinson. I'll just thank you for the very informative presentation again. And so members, if you have any questions now, we could do a couple. So go ahead and raise your hand or comments, or we could just do it at the, go ahead, Nicole.
Hi, yes, thank you so much for your presentation, Dr. Robinson. That was very informative. I will admit I'm a little bit new to the concept of standard of care, so I'm kind of working through this as we're going through the presentation. But one thing that came to mind with your presentation, and I don't know whether or not you can comment on this, but I really see this being very useful for the most vulnerable members of the community. I'm thinking, you know, underserved communities of color. I'm thinking homeless populations is super relevant. So, you know, we were getting into some earlier discussions about not applying standard of care to the practices themselves, to the pharmacies, but maybe in serving these really underserved groups, standard of care being applied to practices could help in being able to serve them, to reach the homeless population, for example, where they're at, as opposed to trying to get them to come into the physical pharmacy. Do you have any comments or thoughts on that?
Well, I certainly wouldn't want to see it limited. Pharmacists are providing direct patient care services through ambulatory clinics in major medical centers, Cedars-Sinai Medical Center for one, and many others, you know, throughout the United States, but certainly throughout California. And so there's very high level services. There are oncology specialists, and there's cardiology specialists in pharmacy, and so almost any specialty you can think of other than surgery in the world of medicine, there's probably a specialist pharmacist who is working specifically with that patient population. So they're highly trained, highly educated. They have their own peer groups that they work with, and they often have a board certification that goes along and that provides additional qualifications. So it really doesn't matter what the socioeconomic class of your patient is. Although I totally agree, it's very helpful for underrepresented populations, but it's helpful for all populations.
Thank you. That's helpful.
Thank you, Nicole. Any other comments? Okay, so with that, I think it's going to be, thank you, Dr. Robinson. Again, please stick around for our discussion session, which will soon follow after all the presentations are done. It is 11:49. I am hoping to take a lunch break about now, if that's agreeable. And thank you to our other two presenters who stayed with us all day today and staying patient to provide your great presentation. So if it's okay with all the members, I'll take a lunch break, hopefully about hour will do. So let's just do 1 o'clock. And then we'll return at 1 o'clock even, if that's okay with everyone.